Hello, Dream Team. Welcome back to our podcast.
Ladies and gentlemen, boys and girls, beautiful people, Dream Team, welcome to another exciting podcast of Here's a Thought with the Max. My name is Lerato Mageta.
And my name is Petola Mageta. And introducing our South African Sign Language interpreter, Calvin Tetani.
Always so good to have Cal in the building.
Yeah.
Welcome, homie. And welcome to each and every one of you.
Yeah.
Yes.
Dream Team, as we continue to celebrate Labor Month, we have a special guest in studio. We have our expert who's going to answer all your questions regarding unfair dismissals and unfair labor practices. George Pelser.
Thanks, hi everyone. Thanks for having me.
I feel like I should put some claps.
I think you have
there,
to.
right?
You have
we need
to.
to do that.
Yeah.
Real quick, George, we were in the car this morning, and my wife said to me, Lerato, baby, don't talk about George's hair. She said, just leave George's hair. I'm just saying, guys, George's hair is like perfect. Do you know what I'm saying? Just talk about his hair all the time. So
Thank
well
you.
put together, guys. All I'm saying
George
is if I needed a
amazing.
lawyer in my
Yeah.
life, I'd go to George just because of his hair. How are you, sir?
George is
good,
incredible.
good.
George, we are so honored to have you. Please kindly introduce yourself to the Dream Team. Who are you and why are you here?
Cool. So I'm George Pelser. I'm the head of legal research at LegalWise. And as we said already, that I'm here to address some labor-related questions.
Yeah.
To see if we can
Yeah.
just... one thing that's a big thing for LegalWise as well is access to justice. And, part of access to justice is understanding what your rights are and what you can do with that. I mean,
Yeah.
you can't get proper access to justice if you don't know what you can do with your rights and what that is. And so this is quite an important thing that you are doing as well, trying to educate
sure.
everybody out there.
100%. And we just want to say very quickly, guys, we did put out a call to action to ask you guys to send in your voice notes with your questions. The response was so overwhelming. So we just want to say to you, thank you so much for participating, because otherwise George would be sitting here and we'd be like, yo, George, here's the thing. We don't have any questions. So thank you so much, guys. Thank you so much for the participation.
Yeah.
It also just says to us that, look, people are going through a lot out there and people have a lot of questions.
Yeah.
So we are so happy to be able to have George today to answer all of those questions, because we are here to empower you guys. You understand?
Yes. And I think it was so incredible hearing people's voices, people's stories, because you can actually hear the angst and the anxiety
100%.
and so we are going to start with the first voice note.
Sure.
Hi guys. So my issue is that at work, I have found that in the 3 months I've been there, I've been performing duties that are over and above my job spec, and my hours are on average about an hour or two more daily. I approached my employers about this because I feel they should be paying me more and we should renegotiate the contract, but they're not willing to come to the table. What can I do about this?
Sure, this is interesting. So I want to play these two voice notes, George, back to back, because the sentiment is the same and I feel like the scenario is the same.
So I work for a small private company and I've been working there for over 3 years now. I'm a permanent employee, and lekgwa le ke le sebetsang ne o na le di-company tse ding ka ntle le e ke berekelang. So what happened is, the company tsa teng di 3 ne out of the current one e ke sebetsang. So o na le business partner a sebedisang nang le ena ke di-company tse 3. So and ba na le mosebetsi o montši, so ba nkopa hore no nna ke ba etsetse some admin work for the company tseo tse 3 ne. And already when I consulted with an HR an external HR person, ka mo tlhalosetsa di-duties tsaka, my daily duties and how much I'm getting for the amount of experience I have and the qualification, explaining hore this is how much I should actually be getting, like my gross income. I've been underpaid for a very long time.
So what I'm hearing here George was just nodding.
Yeah.
George,
I love it.
George,
I love
by
it, guys.
by
Listen,
the time you
it
leave
is 2022 in South Africa. I'm here for the nod.
I got the crux of
George,
it.
by the time you leave here, you'll understand Setswana or Zulu. So the crux of it is that, she's working for a company where the owner has a friend who's got other businesses, and now they've asked her to help in those other businesses. But what's currently happening is that she's still getting the same salary. The hours are long. And I feel like this is a trend these days, and especially with COVID, when some people have to let staff go, people are finding themselves in positions where they are handling 3 or 5 people's jobs. How do we deal with that?
So I think the first thing that we have to look at is the employment contract. That would always be your first point to go to, and if you don't have one. Just to emphasize that you must try and always get, whenever you get some form of employment, make sure you get it in writing. There must be an employment contract. But that would be the first thing. And for this lady, the last one who's now doing business for more than one type of business, so for her it would be, looking at for which company is she actually employed to work for.
Sure.
If there's an umbrella company, for example, there's one big company and they all own all the other companies, does a contract of employment allow her to work for those companies? Because if it doesn't, then you're sitting with a bit of a problem there, because technically they are not allowed to use her to work for those other companies unless it was arranged with her.
Sure.
And then also in respect of the salaries, you are employed, first of all, to work for a certain salary. And then if you work more hours than you are also employed to do in terms of your employment contract, that's overtime. And, in some instances, they are entitled to overtime. I think the threshold now, if I'm speaking under correction, is around 244,000 per year. So everybody earning below 244,000 is entitled to overtime.
Sure.
So that's something they can also look into in respect of, I'm working more hours.
Yeah, I hear you saying that they're not the employer is not allowed to do that. My question is it illegal? Is it against the law?
So it's difficult to say if something is against the law, because especially with labor law, there are certain laws that are in place, and obviously if you don't comply with those laws, if it that's the whole definition of illegal. It's not compliant with the laws. So with that, as I said, it all depends on the contract, and it might be that and unfortunately, some of the people don't always read the employment contracts from top to bottom. So, there might be some hidden clause in there that you are not even aware of. And that's just an off topic now again, but that's something quite important. If you sign a contract, whether you read it or not, you are bound by that contract.
Sure.
Especially because you signed it.
Especially when you signed it. But in this instance, I would advise for both of them, again, go and discuss it. And I know they said that they have discussed it with their employers quite a lot now, but go and discuss it and try and get something in writing. So that when you go, for example, to the Ccma or to the Department of Labor, you have something in writing from both of the parties. If possible, send them an email and let them reply on that email, because then you have something a bit more concrete than this is what my employer told me. They said I must work, or they are paying me more, or whatever the case must be. So try and get that so that you can go to them, because after all, they're not allowed to, you're employed to do one job. Whatever you do outside of that, they have to remunerate you for that.
You know what's interesting with this, with the question and the answer that I'm hearing from you, George? If then they are not satisfied with the internal discussions, right, and they decide to go to the Ccma, can they, because I think what a lot of employees are scared of is being victimized. What if, can they be dismissed once, the manager or the company feels that they are obviously going against certain principles, right? And if you go to the Ccma, how are you covered? What's going to happen to you?
So what I want to answer on that is, so what you're basically saying is if you go and, I want to use the word fight very, very lightly, but if you go against your employer, will they dismiss you purely just for the fact that you are taking us on now? You're not allowed to do that.
You're a problem.
Yes. You're making our lives difficult.
So
they are not allowed to be victimized based on that. You have this right to approach them, to ask for guidance, or to approach another forum and ask them for guidance and help you enforce your rights, what you have. So they cannot victimize against you or even dismiss you on that basis. So while we're on dismissal, there's only a certain few things, in terms of a company's disciplinary code, for example, where they can dismiss you. And dismissal is also one of the last resort matters. Usually it goes written warning, final warning, final warning,
final,
and then dismissal. So it's not something, now I don't like what you're doing to me. I'm going to complain at the Ccma against you or the Labor Department, and the employer goes, okay, then pack your bags and go, because then that will be an unfair dismissal.
Got you.
And talking about unfair dismissals, if they were treated unfairly, let's say they were to be dismissed, what time frames must be kept in mind to refer the matter to the CCMA?
So when you refer an unfair dismissal, it must be done within 30 days of the dismissal, of the date of dismissal.
Okay.
Yes. So if you miss that 30 days, you do have the option to apply for what we call condonation. So you apply and you make your excuses and you say, I'm really sorry, but A, B, and C happened. These are the reasons why I did not refer this to the CCMA within 30 days. It can sometimes get difficult. I've even heard about cases, and when I was still in practice, came across a few cases where now it's 20 years later.
Sure. Yes. What?
I think I was unfairly dismissed. And then unfortunately, you can't do anything about that.
Oh my word.
Have you ever seen a case though where it was 20 years later and the court would hear the matter?
So it depends on, I've personally never seen a case, but you can try your luck, to be honest. I mean, whatever your reasons are.
There's always hope.
There's hope. But whatever your reasons are for not addressing, it can be like, I only realized at a later point. Yes, it would be a lot more difficult to get that condonation and for them to allow you to continue with this matter. But it must be, as soon as you are dismissed, go and think about this and say, was it unfair? Was the correct procedure followed? Was there a valid reason for me to be dismissed? And then if you feel that you were unfairly dismissed and you're not 100% sure, go and get advice, or even still refer it to the CCMA. They will also help you, trying to establish that. So, rather sooner than later.
Got you.
So George, we know that currently in the heat of COVID and post-COVID, what's happening in the workplace is that there is a mandatory vaccination clause or rule or mandate, right? So what do we do? What do you do if you get dismissed because you don't want to get vaccinated? Is that within the rules of the law? Is that illegal? Can you take your managers to the your company?
That's a great
to the CCMA?
Question. It's an awesome question.
It's amazing. I'm ready for this answer.
No, it's an awesome question, but also a very controversial question. Because everybody's still on the fence about the vaccines. You've got as you said, you've got anti-vaxxers, you've got those who's pro-vaccine as well. And the difficulty comes in with there's up until now not very, very detailed laws governing this.
Sure.
So yes, there are laws saying that companies can make it mandatory, but it's also not as simple as, you one morning the big boss wakes up and says, today we are making vaccines mandatory.
That's it.
That's it.
Because it's my father's company. And I said what I said.
Sure. So I think everybody must get vaccinated. The company must look at the risks involved and, the staff they have as well. Any comorbidities, for example, the age, the operational requirements. I mean, if you are a company where everybody comes in the morning and they go and sit in their office, they don't see anybody else, they barely move out of their office. I mean, the risk is lower, in those circumstances where you are sitting with people who are working with the public on a daily basis or in the field. Exactly. So it's really difficult for that. But once the company has decided, after taking all of these aspects into account, that they are going to make vaccines mandatory, then, unfortunately, then that's the company policy then. But the current regulations that's out there as well goes a little bit further, and they do say that if there's someone who refuses to take that vaccine, the company must, consult with this person, try and establish what other options are available, is there maybe something we can put you at another department, for example, or can you work remotely, whatever the circumstances. There's no clarity up until this point about whether you can be dismissed if you, in that circumstance, refuse to take the vaccine.
Sure.
The CCMA, there's 2 cases that I know about where the CCMA has ruled in favor of the employer, where they said that it's not unfair to dismiss a person for this. But the CCMA cases are not binding on everybody.
Sure.
So we are waiting for someone to take this to court to get that clarity. But the possibility is there. If you think about it, it's also now it's company policy. So if you go against that, but as I said, in making that decision by a company, it's not as simple as. So you are allowed also to ask, how did you come to this decision? Or why, discuss it with your employer as well to try and get behind the story and see if there's no alternatives available.
Yeah.
Awesome.
We're going to go to another voice note here from the Dream Team.
Hi there. I'm responding to your current post about unfair labor practices and unfair dismissal. So I wasn't dismissed. I was basically compelled to resign because my company was just finding reasons to make my life very terrible. But in short, my role became redundant, and instead of offering me an exit package, they did not do that, and they just found other really silly ways to try and get me dismissed. But I just resigned because it wasn't worth the trouble. But recently there's 2 other black people who have, one resigned, same case as me, and the other one has an inquiry tomorrow. So it's really starting to feel like it's a racism thing. There's been other people who've been dismissed this way, and I just wanted to find out, instead of going to the Ccma, can one sue, and on what grounds?
Can one sue, and on what grounds?
So that's a very loaded question. There's a lot
because
of
there's
aspects
also
in there.
there's the racism there. Well, there's and I would imagine the employer would say, but there's a perception because you can't prove that you were dismissed. So it's very intricate.
So I'm going to try and unpack it as briefly as possible.
Okay.
So the first thing, she did mention that her role became redundant. So we are looking at possible retrenchment in that instance, because that's the whole point of retrenchment as well, is there's certain circumstances in the company that's not working anymore. There might have been a change. Her position was under that fire line now, and it's not needed anymore. So if we're looking at retrenchment, there must be a certain procedure that must be followed. They must consult with the employers the employees that are going to be affected. Try and negotiate as well, and to see, listen, come up with solutions. Tell us how we can save your job. Tell us how we can use you in the company in another way. And then the company will look into all of that and then decide whether they're going to let go or not. And then there's also possibilities of, certain packages that can be offered, or the law does say that you must be remunerated for a certain amount as well in respect of retrenchment. So that's the first part. The second part, she did say that instead of them going through that procedure, it seems like they made her life unbearable in the office. She actually had no choice then to say that, listen, I'm done, I can't work in these circumstances. So that can come down as constructive dismissal. So she resigned, but it's an indirect dismissal. The employer made it so unbearable that there's no trust relationship anymore. So in that instance, so she can take that to the Ccma as well. She must, first of all, prove that now this was a constructive dismissal. She must go and explain why did she had to resign, what the circumstances were, and then it's up to the employer now to go and explain to the Ccma as well, to say that, listen, this was fair and what we did was proper, and go through that motions. And then the third one, she did address the racial aspect. So that can be discrimination. And you can also refer that to the Ccma. That's a difference. So with a constructive dismissal, you're also looking at the 30-day period. But with discrimination now, you're looking at, you've got 6 months to refer that. So, there's all of those factors that come into play there. But there's definitely, I know she says she doesn't want to go to the Ccma, she wants to sue them directly, but in this instance, you'll have to go to the Ccma, go through that process, because they will assist you the commissioners there will hear the matter from both sides as well and make a fair decision at the end of the day.
Yeah,
I actually went through that, right?
Yeah,
we
yeah,
shared it in another video, guys. I went
we
through
did.
that. Yeah,
we did. So I think what's important really is that I just can't help thinking to myself that there might be some people that are sitting back and going, oh my gosh, you guys are talking about, these steps and go back to my employer and, just kind of make it sound trivial and simple. And I don't want us to negate the fact that some people might be feeling like, oh my gosh, but I've done that, or perhaps taking that route would be completely futile. What is the point of doing that? But what I hear you saying, George, is at the end of the day, guys, if you're going to end up at the Ccma, you need to have followed certain procedures in order to get justice.
Yeah.
If indeed you have been wronged, this is the best course of action. Am I right in saying that?
So just adding, because you are also only as strong as your case at the end of the day.
Sure.
You need to go and prove whatever you want to go and prove and allege in court or at the Ccma.
Yeah.
So having that indication of, listen, I did try to resolve this with my employer, will help you so much at the end of the day, because now it's going to be, listen, this is what you've got. And if you can get it in writing, whatever you're trying to do, and if any responses, that would actually help so much more, because now you're not just going and said, this is what they say to me, and they come, we never said it.
Sure.
Then you're sitting with that dispute as who's the most reliable witness at the end of the day. But if you've got something on paper, I mean, it's going to be difficult for them to come and say, we never said that. I don't know who wrote that email. So it's really important to try and, in some instances, it might be necessary to skip all of those, the more serious aspects, but, try wherever you can, try that, because it will help you in the future.
I didn't say that. Yes, you did. I didn't say. Yes, you prove it. Prove it, guys. Prove it.
So, George, you spoke about discrimination earlier. How difficult is it to prove that you've been discriminated against?
So it's sometimes it's easy.
Okay.
And sometimes it can be a bit difficult.
Okay.
And so when we're looking at retrenchment, for example, and you are a pregnant woman at that stage, and you feel that, this is the only reason why I am being retrenched is because I'm pregnant, or I'm not being considered for the position because they saw I'm pregnant.
Sure.
So the laws are very clear. The labor laws are very clear about you're not allowed to discriminate either on race, on gender, on pregnancy, marital status. You're not allowed to do that. But it is difficult, because how do you now go and say, this is the reason why I'm being retrenched? So you have to look at the underlying circumstances as well. So if you are the only pregnant lady that's being retrenched, but everybody's fine, then there might be some discrimination involved there. It's a bit dodgy there. But if, for example, there are another pregnant lady
if they're
that's
all
also
pregnant.
If they're all pregnant, you're also looking at possible discrimination there, because then they're definitely singling them out now.
For sure.
But also having to look at other circumstances. So depending on, let's say, for example, part of the process, so retrenchment can get quite complicated, but they're also looking at your performance, for example. So if you are the worst performing employee,
like you're just not
and
great,
you're pregnant,
it might not necessarily be that it's because you are pregnant.
It's not because you're pregnant.
I
don't know who needs to hear this. It's not because you're pregnant.
So it is quite difficult, but having to look at that, and I think we've seen now the past few years, discrimination is quite a serious matter, and forums and courts are taking it quite seriously as well. So don't sit back and think, I don't know how I'm going to prove this. Let me rather keep quiet. I mean, go get legal advice, get your evidence sorted out. Look at, okay, this is the reason. Okay, but that lady is also pregnant. That one, I can see kind of a pattern happening here now. Get all of your evidence together and get legal advice and say, what can I do? Do you think it's discrimination? Or if all else fails and you don't have that legal advice, go to the Ccma. Report that discrimination. They will investigate the matter.
I got you.
Guys, get that legal advice from LegalWise. Be LegalWise, man. I wanted to ask this question, my love. So with the lady, I think, sometimes when you're being pushed out, you feel like it's constructive dismissal, right? Sometimes, I think you might feel frustrated and resign immediately. What are the consequences of immediate resignations?
So with that, you're looking at, so we are looking at the Basic Conditions of Employment Act, and your employment contract will probably give some notice periods.
Recourse or
So first of all, when the Basic Conditions of Employment Act, the legislation states that when you resign, you must give notice period. Your contract will also say you must give a certain period of notice. So the first aspect there is you are breaching your contract now. It's not that I'm saying you are not allowed to do that, but I'm trying to explain the consequences and something you have to think about. So you are breaching your contract now. So which means that if you are immediately resigning on the 3rd of the month, you will probably also get paid up until the 3rd of the month.
Sure.
You're not going to get your full month's salary. And in some instances, it might even be that because you are supposed to work a notice period, that the employer will deduct that amount from what they owe you at the end of the day. So it's something it's possible to do. And in some instances, it's necessary to do that.
Guys, what you're saying is, don't do it.
Don't do it.
I'm not saying don't do it. I'm saying think about it because there are consequences around
Don't do it, guys. Okay, George is not saying it. I'm saying it.
The consequences are big.
Yeah.
So
that's
do you
huge.
also forfeit UIF? That's what I'm hearing. Because you forfeit a lot of your benefits.
So when you resign, you are not entitled to UIF.
Okay.
So when we look at UIF, I always say it's the circumstances where you don't necessarily have control over.
Okay.
You are being dismissed.
Or retrenched.
It's not your choice at the end of the day. You are being retrenched. It's not your choice. It's coming from the
I
employer.
understand.
When you resign, that's your choice. You decide to be unemployed. So the UIF will not then cover that part.
Even if you feel like you were pushed to resignation?
So when we get to constructive dismissal,
Yeah.
then that's a dismissal necessarily.
Got you.
Yes.
Got it. That's
So
the difference. Got it.
Yes, you resigned,
Yeah.
but
It
it's
was
a constructive
dismissal.
dismissal.
Got
But
it.
only again, then that will have to be proved
Sure.
at the end of the day before the UIF will probably look into that.
Super. Can we go to another voice note?
Yes, we can go to another.
Wow.
I would love to know if it's possible for an employee to be retrenched or fired while they're on a sabbatical.
That's a good one. That's a good one.
That's an interesting one. I've never thought about that.
Yes.
Yeah.
So I think the first point is to look at what's a sabbatical. So
Okay.
there's no entitlement in law to a sabbatical. So when we look at sabbatical, it's usually you get a few months' time off. It's usually also unpaid, but at least your job is secured. You will come back to your job.
Okay.
So in that instance, it's always arranged between you and the employer. So you'll first have to see what was the arrangement before you went into that sabbatical. There would probably also be something in writing.
Right.
But when we're looking at the possible retrenchment or dismissal, so with retrenchment, as I said earlier on, there's certain procedures that must be followed. They cannot just retrench without consulting you. When we look at dismissals, there's certain procedures that must be followed. They must hear your version of the story before they can dismiss you. They cannot just dismiss you, on the spot for no reason at all. So we're looking at, it might be possible if you were involved in all of these procedures during your sabbatical period. So if you are 2 months in your sabbatical and there's still 6 months left over and they say, listen, we're going through restructuring, we're going to retrench, we need you to participate in the consultations. We need to inform you about A, B, and C. We need to do this. We need your feedback on that. Then it might be possible because you were involved. The difference is, and I don't know what the circumstances are here, but it's not possible in the sense of you are on your sabbatical, afterwards you come back and then your office has been given to someone else. Your parking
There's
spot
Johnny
is not there anymore.
sitting at your desk.
Yes.
Yeah.
That
And your
would be
family
unfair.
picture is still
Oh,
there
so that
on
would
the
be
desk.
unfair.
Yes. So
Okay.
they have to involve you.
So-
The other thing with dismissal is, dismissal is usually based on, for example, misconduct. If you are not there for 6 months, what did you do wrong to be dismissed in that 6 months?
Well, so here's an interesting one. Say you're not there for 6 months, and in month 4, you got a DUI, or you got in trouble with the law. There was some case against you, right? I'm just putting it out there.
Yes.
Yeah.
What would the grounds be for dismissal when you're on sabbatical?
So when you're on sabbatical, that's what I'm saying. That's where because what would the grounds be? That's the question basically. Because you're not at work. Unless there's something, that might have come to light now, but then again, they will have to involve you. They need to get you in to say, come and
right. So if they discovered that you had been committing fraud, within the company,
and the same way,
while you're on the beach in Miami,
driving under the influence, for example, if your job
is a driver,
then that will influence your job.
Got it.
There's a lot of factors, and that's bringing me back to what I said in the beginning with labor law. It's a bit difficult sometimes because there's so many variables that can be applicable.
Sure.
That's, I think, always with these types of things, go back and say, what was the procedure that was followed? Was there a proper procedure? Was I even involved? And then look at what was the reason.
Super.
Behind that.
So what's interesting is that I actually never thought about it. So you actually don't get a salary while you're on a sabbatical?
Unless it was agreed to.
Oh, yes. Okay. And talking about salaries and money, I mean, we know that since COVID, the economic climate has been, very unfavorable, right, to a lot of people. So are payments of bonuses and 13th checks compulsory?
So it's not compulsory. So there's no law that says, unfortunately.
That's too bad.
So there's no law. There's no, the laws doesn't say everybody's entitled to a 13th check or a bonus. That's something you agree to with your employer at the end of the day.
Okay.
So when we're looking at 13th check, that's quite simple. At the end of the year, or in some companies will do it in your birthday month, for example, you'll get double your salary, for example, for that month.
I have a birthday every month. I'm just saying.
Well, then you should be very old by now. But and with bonuses, that's usually in respect of your performance as well. It's linked to your performance.
Got it.
So it's not that you're always entitled to this.
Yeah.
And then we're looking at economical factors that might come into play. If the company is not making a profit and they cannot afford to give these bonuses or to give 13th checks, they must notify you in advance as well, and be able to prove and substantiate why they are not able to do that. So it's also
proof to who?
To every request. So you can require and say, okay, cool, you're not paying us our 13th check. Why? And then they will have to, because if it's in your agreement, if your agreement says you're entitled to a 13th check and you're entitled to be considered for bonus, for example, and they just don't do that at all, then it's breach of contract as well at the end of the day. But you need to go and read those clauses very carefully, because they will necessarily always say in the discretion of the company, depending on financial circumstances. And that's where, that's where you can go and inquire.
The fine print.
And you can inquire
terms and conditions apply.
Why are you struggling? If you feel that you can inquire about that as well. So it's not something that you are entitled to, unfortunately.
Got you.
I love this.
Yeah.
I think we're going to wrap it up with one more question.
Let's do it.
We'll wrap it up with one more
voice note.
So I'm not sure if this is an unfair labor practice, but I've experienced and other people have experienced changes in hierarchy when it comes to you getting the next reward or award. I'll make an example of, so there's different levels in our company. Those levels are specified as, okay, this position belongs to this level, etc., etc. So what happened was, when it came to my turn, I was given the title, I was given the roles and responsibilities that go with that title, and yet I couldn't be put on that band.
Mm-hmm.
And that band obviously comes with benefits. The extras, the extra benefits, etc., etc. When I did question this, I was told that it's because the size of the portfolio doesn't match the band. But this is the opposite of what they had said to us when we had a briefing of these bands, etc. And it had nothing to do with how big the portfolio is. It was all about the work that you're going to be doing, your roles and responsibilities in essence. So currently I'm doing the same roles and responsibilities as people in this band. I'm doing a 2-man job, and yet I'm told that I am not of that level. So how do we go about this? How do we look into this? How do we try and change this without making too much of a noise? Because once you start making noise, you become the target of any company.
So again, that one addresses quite a lot.
Quite loaded.
And something that we did touch on just a little bit earlier on is the fact that I heard she said, they told us this. So
and George is
again,
going,
writing.
where's the
where is it in
contract?
writing? What is the contract
So important.
saying? So it's also, sometimes depending on the circumstances, it's not always necessary in every circumstances, but it might be that, when they tell you something, just confirm it in writing yourself if they don't do that.
Sure.
If it's not what they told you,
smart.
they
Smart.
would reply with that and say, this is
Smart.
not what we told you. You misunderstood us, for
Yeah.
example.
Sure.
So now you are at least you've got them. Like you said, I'm going to get 20,000 Rand a month from next month on. I'm understanding this correctly. This is my understanding. Then if they don't reply back to that.
Listen, guys, I'm so excited about this 20,000 that you communicated to me then, right?
Just don't make up stories now just to go and say.
Well, like you said, I mean, if
to confirm.
right?
Yeah.
Because
Just to
then
confirm.
in the response to that mail, they would be like, oh, you've worked so hard, well done, you deserve it. Then that's confirmation. That's confirmation,
Or
right?
they will, if that's confirmation, or they will come back and say, no, you misunderstood us.
Right.
Yeah.
This is not what we said.
100%.
Yeah.
Sure.
So I think that's one element we can look at. The other one is, again, might be unilateral change of contract as well. And the terms of employment, she was employed to do a certain job. Now they are technically promoting her,
Yeah.
but
Yes.
they are also not promoting
Yes.
her.
Yeah.
And that might, because with unfair labor practices, promotion is one of the factors that is considered as unfair labor practice as well. So if that wasn't treated fairly and probably conducted, then it might be considered unfair labor practice, because she's technically promoted, but she doesn't get the financial benefit that comes with the promotion. She's on a higher band. She's on, a different title, for example.
But doesn't get the benefits.
But she doesn't get the benefit as everyone else. If there's everyone else on that level gets
Yes.
the extra benefits, she's doing the job, she's got the title, everything, and she's the only one not getting that, then it can be considered as
So
unfair.
what's the recourse? Because, I was so excited about saying, guys, my takeaway is put it in writing, have it in the contract. But in this instance, she's being denied the benefits. She's being denied it being put into writing. So what is her recourse?
So with that, the CCMA again, you can refer the unfair labor practice to the CCMA.
Yeah.
So we've discussed now 30 days for dismissals,
Yeah.
6 months for discrimination, 90 days for unfair labor practice. So
Got it.
refer it, get your evidence together and refer it to the CCMA, and they will sort it out. Something that I wanted to say earlier on as well is like, it's also about a lot more cost effective to go to the CCMA for that lady who wanted to sue directly, for example.
Yes.
It's more cost effective to go to the CCMA than, going through that high legal cost necessarily, where you do have that avenue available to you. So I know everybody's, we're talking about labor and we always just say CCMA, but they are there for the purpose. They are there to help the employees as well and to listen to both sides. I mean, with all of our laws in South Africa, basically, if you go to court for any matter, you have to listen to both sides of the story.
Sorry, George. Sorry.
No, that's
Random question.
Yes.
What does CCMA stand for?
The Commission for Conciliation, Mediation and
Arbitration.
Yes.
You know what I wanted to ask? I think a lot of people are quite disheartened as far as the CCMA is concerned in terms of the timelines, because sometimes some of these things can drag on for long, especially you've just been dismissed, there isn't an immediate income stream. Now you have to go through this process. It's emotionally draining. It's stressful. How long does it usually take for an issue to be resolved at the CCMA?
So it varies. It's difficult to say, it will be resolved within 6 months, because you have to look at the influx of matters at the CCMA. They are trying their best to get to everything. And it's important to note that these time frames, it seems like it's unfair. It seems like you're being done in for some reason. But it's important for these time frames to be followed as well, because that is how you prove that the procedure at the CCMA was also properly conducted.
Got it.
I mean, you can't just go and, let's take, for example, you are my employer. I can't just go and do unfair dismissal, and then 2 days later the CCMA says, okay, it was unfair dismissal, and then 3 days later you must reinstate this person, or you must now give 12 months salary, for example, or whatever the case. You need to, and to also take into account, for example, if you have to send something by post, it takes a while. So there's usually time frames to try and accommodate for that. Even when you send something via email, give a few days, let them react on it first. If they don't react, then you go to the next step, for example. So these steps are there for a reason. I know it sounds like, or it sometimes feels like it's not doing me any favors at this stage, but it's there for a reason. It considers everything. But if you feel, it's dragging quite a lot, go and do the CCMA and just ask them, what is happening with this matter? Why is it dragging so long? Is there any way we can, fast forward it a little bit?
Yeah.
I love it.
Love it.
Your contract, guys. Make sure that you read your contract. Make sure that you have a contract. Let's start there, right? Make sure that you have a contract. Make sure that you read the contract.
Yeah.
Make sure that you read the fine print. If it's even in radio today, when you hear adverts and they go, terms and conditions apply, right at the end. That's the fine print, right? Make sure that you read it. Make sure that you go through all the procedures necessary in order for you to strengthen your case.
Yeah.
All right?
Yeah.
It might seem tedious. It might seem boring. It might seem unfair because you're the one that has been done against, right? And why should I go through listen, just do it. Make sure that you gather your portfolio of evidence so that you know that by the time you need legal representation, that you're backed up. This is all you need to do. And it's simple, but I think our emotions sometimes make it complicated.
Yeah.
Right?
It does get, you get at the point where you're like, I'm not in the mood to do this now.
Sure.
And then it gets to a point where it's maybe too late at some point, or you'll lose your evidence or something like that. So also act fast to add on your list. Try and act as fast as possible with these matters so that, you can address it as quickly as possible.
Yeah.
And I think, George, we can't, stop reiterating the importance of getting legal advice.
Yes.
Yeah.
Because people do not know what they do not know. You love saying that.
Yeah.
Right? So I think, my parting shot is that, guys, get legal advice.
Yeah.
Get legal advice. Just don't do things blindly.
Yeah.
Yeah.
Be LegalWise.
Exactly.
So I was saying, guys, George, thank you so much.
Thank you, George. Thank you so much for your time.
You are actually, apart from my parents, you're the second guest that we've ever had in this podcast studio.
Yeah.
That's awesome.
So you're family now.
Dream team, we appreciate you so much.
Yeah.
My baby, I appreciate you. George, I appreciate you.
Yeah.
Calvin, we appreciate you, homie. Thank you so much, guys.
Thank you, family.
Remember here, we like, subscribe, comment, share, turn on that notification bell to know every single time we upload a new installment. And to all the Dream Team, you're welcome.
Yes.
Because we're putting you on, guys. This is education.
I feel so educated.
Right?
I feel so much richer leaving the platform today.
You know what it is. One time, too real. Oh yes. Peace and blessings, people. We out. Be LegalWise, guys. Don't play yourself. I always say, don't play yourself. Peace.